Good morning, everyone. On behalf of Main Partner Trust, I would like to welcome you to another event in a series of our webinars dedicated to wealth planning and asset protection mechanisms. Today, we would like to concentrate on inheritance planning. It has been a very requested subject, and especially during the last year, we have received a number of requests from client and prospective clients to advise on that. Therefore, we have decided that this is a high time to discuss the subject also with you on this forum. It will be a very vast subject matter, and due to time concerns, we will be only able to touch the top of an iceberg and only present to you an overview of potential structures and discuss with you the advantages and disadvantages only on a general level. Obviously, there is no one perfect solution for everybody, and therefore, if any of the subjects that we will discuss with you today will prove to be interesting, we highly encourage you to contact us so that we can discuss with you a potential solution, a more tailored one for you and for your family. Before we move to discussing particular solutions, I would like us to stop for a while and think why you might need an inheritance planning at all. All the countries have their inheritance rules which govern in detail how the assets are being transferred from one generation to another. You can always change them to a certain extent by signing a will. And if you have been relying on any of these solutions till now, you have to bear in mind that both of them have their deficiencies. And here comes the role of an inheritance plan. The role of it is to mitigate and to limit to the extent possible the deficiencies of these default inheritance rules. Have a look at what a good inheritance planning can offer you. First of all, it can prevent the assets from going to unintended people. Meaning that, in example, if you would like to support upon your death a more distant family member or a friend, default inheritance rules might not allow that. It can also prevent the assets from going to being divided in unintended proportions. Here as an example, if you have a child with disabilities, maybe you would like to support it more than children who can sustain themselves. What is also important, inheritance plans and structures that we'll discuss can also change the timing of the distribution of assets and spread this distribution over a longer period of time, which might be beneficial, especially in case of young inheritors. Inheritance plan can also help you to avoid probate. And here, short pause to explain what is a probate. It is a legal proceeding where a judge sits down and finds out first what are the assets which are subject to inheritance, and later decides on how they are divided and between whom. In case of a good inheritance plan, you can avoid this legal proceeding, which in many cases can prove to be very long and costly, in particular in case of assets which are spread around the globe in many different jurisdictions, or in case of beneficiaries who are living in different countries, and also in case of a testator himself living in different jurisdictions. This can cause conflicts or doubts as to where the proceedings should take place and in accordance with what rules. Obviously, having involved in illegal proceedings can cause family conflicts and also do not support the confidentiality, which can be offered to you by a good inheritance plan. Inheritance plans also have additional advantage, which is their asset protection role, which basically acts as a shield over the assets being inherited and protects them from the creditors of both testator and also inheritors. So all of the discussed objectives of a good inheritance plan can be achieved via different structures and different strategies. All of them, or in case of different strategies, some of them. What we will discuss today are foundation, a trust, a family holding company, and a fund as standalone structures. But you have to also understand that this is possible to use them as a combination. Let's start with a first potential structure, first potential solution, which is a foundation. A foundation is a legal entity which is created to realize a purpose which is decided by the founder, and such purpose can be private, like for example, inheritance plan. Foundation is a concept known to many different jurisdictions, but because we are limited by time, we will concentrate on one example of a foundation, being a foundation set up in Liechtenstein. Liechtenstein is historically known for its foundation regime. It has also a convenient time zone and proximity to Russia, which might be very important in case you need to come and sign in person a document or meet with, for example, a foundation council. Foundation can be set up very easy. It acquires only signing of foundation articles and more specifically a declaration of establishment. You do not need to appear in front of a notary, in front of any governmental body or a court. Creation of the foundation needs only to be notified to the Land and Public Register Office within 30 days. There are also some additional documents that you may decide to sign, which will govern the foundation. These are the bylaws, which usually deals with issues related to the beneficiaries, so the inheritors in case of inheritance plans. You may also sign regulations which are governing more internal arrangements of the foundation and can set up, for example, asset management targets for the foundation. Foundation as a legal person has to have a capital, and in case of a Liechtenstein foundation, this capital is 30,000 Swiss francs, euros or dollars, and you can always increase this capital. Now let's have a look at the typical structure of a foundation. Obviously, in the center of a foundation is its founder, who establishes the foundation, also decides on the purpose of the foundation, and eventually transfers the assets to it. Another important body, and the only mandatory executive body of a foundation, is a foundation council, which manages the foundation. It also represents it towards third parties. A foundation council has to consist of at least 2 persons, one of which has to be a Liechtenstein trustee or a person with a similar status. A founder can also appoint himself as one of the members of the foundation council. Every foundation has also have to have a representative, which is a person who represents the foundation in front of the governmental bodies in Liechtenstein. It also acts as a process agent. Finally, we have also beneficiaries who will be the inheritors if the foundation were supposed to function as an inheritance plan. So the assets of the foundation are basically managed to their benefit. Last 2 bodies are non-mandatory. However, the founder may also decide to have them. First of which is a control body, which verifies once a year if the assets have been managed and distributed in accordance with the foundation purpose. A foundation may also choose, a founder may also choose to have a protector who mediates and represents the interests of beneficiaries in front of the foundation council. A protector may also act as a collator. A collator is a person who is choosing the beneficiaries or who has a right to identify the date, the amount, and the conditions of the distributions. A collator can also be a separate person. Now let's move to advantages of foundation as an inheritance plan. One of the major advantages of it is a very fast and easy setup that we have just discussed. Foundation also has a very flexible structure. Here, let's move back to the previous slide. On top of the foundation council, the founder is free to set up also other additional executive bodies apart from the foundation council, and is very free with respect to who are the members of this executive bodies. This can be, once again, members of the family or he himself, and also the functions of these executive bodies. They can advise the foundation council, they can have a right to veto, to instruct. The only thing that such additional executive bodies cannot do is to represent the foundation. Here, a potential solution would be an issue of a power of attorney by the foundation council to some members of those bodies. Foundation offers also a limited but still continued commitment of the founder in the life of the foundation. As mentioned before, a founder can appoint himself as a member of the foundation council or other executive bodies of the foundation. He can also revoke the foundation. He may reserve for himself a right to appoint and dismiss the members of the foundation council. Some part of the commitment, it's still possible. Foundation also allows for a very flexible system of beneficiaries and beneficial interest, which allows to create a plan, an inheritance plan for many generations to come, which is not possible in case of a will or in case of typical inheritance rules. What do I mean by that? Founder can freely choose who are supposed to be the beneficiaries of the foundation. He can also freely set up the interest of each beneficiary. He can decide on the timing of the distribution and also on the conditions of such distribution by, for example, setting up certain age when a beneficiary can obtain a distribution of assets, or certain life goals like, for example, finishing studies and so on. Due to that, the foundation also allows for the avoidance of forced heirship rules, being these inheritance rules that I mentioned at the very beginning, where the law decides for yourself how the assets are going to be divided. Because the founder transfers the assets to the foundation, who is eventually a separate legal person from him, the assets upon such transfer do not belong to the founder anymore. And also, until they are distributed to beneficiaries, these assets also do not form part of the estate of beneficiaries. So it means that in case of death for either the founder or the beneficiary, these assets are not subject to the lengthy probate that we discussed before, and are not subject to these legal proceedings. Foundation also allows for an asset protection and protects the assets being subject to an inheritance plan against the creditors of both founder and the beneficiaries, as long as they are not distributed. It also helps to prevent the division of specific assets. So, for example, in case of the legal proceedings mentioned, if they would be also conducted with respect to assets such as an operational business being within the family, or a real estate, obviously dividing it might not be beneficial. So it's better to keep it under the foundation and allow for the beneficiaries to receive an income from it over a longer period of time. Foundation gives beneficiaries certain information rights, certain basic information rights, and also provides for a high level of confidentiality. As mentioned at the very beginning, the creation of a foundation, of a private foundation, it has to be notified to the land registry. However, the details of beneficiaries and the details of the founder himself are not provided to the authorities. Now let's have a brief look at the potential disadvantages of this structure. Obviously, if the assets are transferred to the foundation, the founder himself loses the full control over these assets. He can keep for himself certain rights that we discussed before, such as appointment of foundation council members, revocation of the foundation, and so on and so forth. However, the more broad these rights are, the higher the risk is that somebody might claim that actually the transfer of the assets into the foundation has not been effectively done. And in the most extreme cases, it is even possible that the creditors of the founder might pierce the veil of the foundation. It can also have certain tax consequences, meaning that the assets belonging to the foundation might be taxed in accordance with the rules applicable to the founder as not being effectively transferred. There are also certain limitations of beneficiaries' rights, meaning that very easily information about the foundation might be not provided by the Foundation Council to the beneficiaries, and the Foundation Council has, I would say, a number of reasons for which they can deny such right. For example, if a beneficiary is not personally concerned in the matters of the foundation, there is another reason called for important reasons to protect the beneficiary, to prevent, for example, a young person's idleness after he has learned or she has learned about the beneficial interest. Also, in case a foundation has chosen to have a control body, also these information rights can be limited. Another disadvantage, a potential one, are limitations of distributions being made to beneficiaries. Here, the Foundation Council can deny the distribution of assets in case it would diminish the distributions being made to the creditors of the foundation. Obviously, it is pretty easy to create such additional creditors of the foundation by the Foundation Council by creating legal work that needs to be done and so on and so forth. So here is definitely a room for potential misuse of this rule. What I would like to also mention is a liability of the Foundation Council, meaning that Foundation Council is responsible for any negligence, and in case the founder himself would like to be a member of the Foundation Council but would not be involved to a high extent in its functioning, there is always a risk that he might also be held liable as part of the bigger body. The last disadvantages and risks related to the creation of foundation are related to the Liechtenstein as a jurisdiction itself. Liechtenstein is a country with a codified legal system, same as Russia and as opposed to UK and to Cyprus. Therefore, the laws of the country are less flexible and are lessly reflecting the situation and the business practice. Also, court precedents do not have the power of law and can be easily deviated from. You also have to understand that foreign judgments cannot be always automatically enforced in Liechtenstein, who only have legal international treaties concerning enforcement of judgments and their recognition with Austria and with Switzerland. So this can be beneficial to some extent in case of asset protection, but in case the beneficiaries would like to enforce their rights towards the foundation, they can only do it in Liechtenstein. And here I would like to mention a few words about our personal experience made with Liechtenstein foundations and maybe more experience made by our clients. So while we're working with foundations from Liechtenstein, we have came across a number of very unpleasant cases related to Russian and non-Russian origin founders and also beneficiaries. Cases that we would like to briefly discuss, they involved, for example, a non-disclosure of conflict of interest, while the Foundation Council didn't reveal that they also have certain interest in the asset management. Foundation Council has also been involved in redomiciling companies belonging to the Foundation Council from more convenient jurisdictions to Liechtenstein, and obviously later providing administrative services to these companies. It was also related to massive overcharging and, the worst of it all, to the refusal to distribute the assets to the beneficiaries. Finally, Liechtenstein itself involves a much higher cost than some other jurisdictions, which is not necessarily justified by a higher quality of work. So as a potential alternative to a foundation, let's discuss now a trust. A trust in every jurisdiction is always a legal arrangement where the owner of certain assets, a settlor or In case of an inheritance plan, a testator transfers the assets to another legal or natural person, being the trustee, to hold on and to manage these assets for the benefit of other people, called in this structure beneficiaries, who are the people who are supposed to inherit under the inheritance plan. Once again, trusts can be set up in many different jurisdictions. For the purposes of this presentation, we would like to discuss with you a trust set up in Cyprus, which we believe offers a convenient geographical location. It's a member to EU, and most importantly, its trust law is largely modeled on long-established and very well-known English Trustee Act, which dates back to 1920s. There are two parallel trust regimes existing in Cyprus, first of which is a domestic trust regime, and it is available to settlers who are Cyprus residents and their beneficiaries. The second type of trust is called Cyprus International Trust, and it is available to settlers and beneficiaries who are not residents of the Republic of Cyprus in the year preceding the year of the creation of such trust. Both of these trusts offer a similar level if we talk about the asset protection, they both can be very well used for inheritance planning. Cyprus International Trust can only offer a higher extent of involvement of the settlor, at least from a Cyprus law perspective. Same as a foundation, a trust can be set up very easy. What it requires is only drafting and executing of the trust deed and the transfer of the assets to the trustee into the trust. Apart from the trust deed, which is a central document, the settlor may also choose to sign a letter of wishes. Such a letter is a non-mandatory document, but it can provide certain useful guidelines to the trustee as to how the assets should be managed. It can also give some guidelines as to how the settlor would like the assets to be distributed. Same as in case of foundation, you also do not need to be present in front of any notary, court, or any administrative body in Cyprus or nowhere else. The trust only needs to be stamped so that it can be later used. Hopefully it's not necessary, but so that it can be used in front of Cyprus courts. And you have to also do certain notifications to the regulatory bodies in Cyprus. But also here, no information on the settlor and no information about the beneficiaries is being recorded or provided to third parties. Let's have a look at the structure of the trust. The central person here is the settlor, a person who establishes the trust and transfers the assets. Another person is a trustee. As we mentioned earlier, it's a person who manages the assets. In Cyprus, in order to be a trustee, in majority of cases, you need to have a license of a Cyprus Securities and Exchange Commission. In case of certain trusts, it might also be advisable to set up a private trustee company instead of a professional trustee. It's a company who is working as a trustee, who is managing the trust, where the directors could be your family members or you yourself. Later we have beneficiaries, which are the persons who are supposed to benefit from the trust, so the inheritors. As in case of a foundation, you can also decide to appoint a protector, which is an independent third party who is mitigating between the beneficiaries and trustees, who represents basically the interest of beneficiaries. In addition to these bodies that we just discussed, you can also decide to have certain advisory bodies which can advise the trustee and may consist of friends, relatives, beneficiaries, qualified advisors who can advise the trustees with respect to various matters and who have in particular an insight into the current family status and needs of beneficiaries. What are the advantages of a trust as an inheritance structure? Same as the foundation, a big advantage is a very fast and easy setup of the structure and its flexible structure that we have just discussed. You may also, for example, decide to set up a trust which has underneath a holding company, which would add an extra layer of protection for the assets themselves, because not all jurisdictions might recognize the trust, same as foundation. And whereas the companies are known worldwide, and it is also more difficult to pierce the corporate veil. Also, adding a holding company into the structure with a trust can add an element of control back into the structure. In particular, if you or a family member would like to be a member of this board of directors of such a company. Same as in case of a foundation, to a limited extent, it's possible to remain some commitment into the structure by the settlor. You can have a right to revoke the trust, to appoint and dismiss a trustee and the protector, or to give the consent to remove the beneficiaries or to add beneficiaries, to change the jurisdiction of the trust or amend the trust deed. Obviously, you can also give your directions and guidelines to the trustee by signing a letter of wishes. In case of Cyprus International Trust, also some further commitment is possible. Trust offers, similarly like a foundation, a flexible system of beneficial interests, allowing the estate planning for many generations and allowing for the avoidance of forced heirship rules. So because it is very important, once again, I will recap that you are absolutely free here to choose who will be the beneficiaries of the trust, as well as how the assets shall be divided between them, also when it shall be divided, and you can add certain conditions of such distributions. Because the trust funds are being transferred from the settlor to the trustee, there will be no lengthy probate in case of settlor's death, because simply the assets do not belong to his estate anymore. And the same applies to beneficiaries. As long as the assets are not distributed to a beneficiary in case of his or her death, such assets will not be subject to the probate. Trust allows also for the protection, this asset protection against creditors and claims from third parties. It also allows for the prevention of division of specific assets, as we mentioned before, such as operational companies, real estate. Because the trust assets can be distributed to the beneficiaries over a longer period of time, they can also protect the assets against the so-called spendthrift beneficiaries who might not necessarily deal well with receiving a large sum of money at once. In case of a trust, beneficiaries also retain certain information rights, especially with respect to accounts of the trust. The trust also provides very high level of confidentiality. None of the particulars provided to governmental bodies in Cyprus involves informing them about the identity of beneficiaries or the identity of the founder himself. An advantage of a trust is also liability of a trustee, who is liable for his negligence in case such happens. What I would also like to mention as advantage of a trust is a long established and already mentioned very trusted trustee law, which is based on the English model. Enforcement of judgments, as opposed to Liechtenstein, for example, Cyprus being a member of the European Union, his judgments are recognizable in all European countries, which might be very useful in case of assets being located in the EU or beneficiaries being located in the EU. Also, Cyprus has a number of international treaties with other countries with respect to the enforcement or recognition of judgments, with Russia as well. Cyprus offers also a fair and trusted judicial system, Here, as an example, a bit unfortunate one, I would like to mention so-called Rosinka case. It relates to a secure gated residential community in Moscow. The founder of this complex decided to place the ownership of the complex under the Cyprus Trust. In order to prevent and protect the assets for his two sons, Vladimir and Alexander, as trustees, he has chosen a very well-known Cyprus law firm. The case is very complex, but in a nutshell, the structure functioned very well and without major problems for as long as the trustee lived, the settler lived. A couple of years after his death, the trustee and the beneficiaries fell into a dispute regarding the management of the assets, and what started were legal proceedings, where both parties claimed that the other party was attempting to illegally take control over the assets. In an attempt to take the control over the trust assets, the law firm was found to have approached and bribed the Deputy Attorney General to bring criminal proceedings against the two sons, and the Cyprus courts later found the law firm and also the ex-Deputy Attorney General guilty of bribery, of corruption, conspiracy, and also in case of an Attorney General of the abuse of power. This case, however, very unfortunate, has proven that the justice can be effectively sought in Cyprus. Even if on the other side you have a very powerful law firm or a known politician. To add to that, the last advantage, we believe that Cyprus offers a very high quality of work and also is a very cost-effective jurisdiction. Now let's move briefly to disadvantages. Same as in case here of foundation, in order to obtain the asset protection function, so you have to transfer the assets into the trust. So here is a flip coin of disadvantage. You eventually have limited control of the assets because you're not the owner anymore. The trust structure might not be recognized in all jurisdictions, but as mentioned before, you can mitigate this risk, this disadvantage by, for example, introducing companies into the trust structure. Later, disadvantage, for example, if the trust deed is not well drafted, the trust and its assets can be open to attacks and challenges from creditors and third parties and be considered a sham. So when drafting the trust deed, you have to remember that yes, you have a right to keep certain rights for yourself as a settlor, but the more you add, the higher is the risk that the trust itself will be considered as void and sham, which can have consequences on both the asset protection level and also can have certain tax consequences by attributing the trust assets to the founder. And the last, misuse and abuse of power by trustee. Well, I do not see it as disadvantages per se, but as in case of any other structure, it's always a risk that persons involved might simply misuse or abuse the power. It can be also mitigating that, for example, by use of a protector who will be monitoring what the trustee is doing, as well by using a regulated trustee, for example, licensed by Cyprus Securities and Exchange Commission. So let's move to another option that is out there. You may also choose to set up a so-called family holding company. What it is? A company whose shares belong solely to you and your family, and underneath there are assets who are belonging also solely to the family members. If such a setup is relating to a given company, such company can be called a family holding company. As in case of other structures, companies can also be set up in many different jurisdictions. There are also many different types of companies in every jurisdiction. As an example for yourself, we have prepared an example of a Cyprus private company limited by shares. It is not very difficult to set up a company limited by shares in Cyprus. However, it's already a little bit more cumbersome than in case of a foundation or a trust, where you just simply sign an agreement, foundation articles, or a trust deed. Here you have further documents that needs to be signed. It's a memorandum and articles of association. And later you have to also register the company with the Register of Companies. As to the memorandum and articles of association, they deal with issues such as company's name, the objects. They include a limited liability clause, a capital clause, and so on. The articles, they regulate a more internal management of the company. Both these documents are available to third parties at the Register of Companies. In addition to that, you may choose to sign, and in case a company is supposed to serve as a family holding company, it is very advisable that you sign a shareholders agreement. It is not required, but it also adds another level of relations between the shareholders, this time on a more contractual level. For the approval of the company in Cyprus, you need around 2 weeks, I would say, for the approval of the name, 5 business days, and later for the registration of the company, 7 to 10 business days. However, what takes the most amount of time is not really the registration stage, but the preparatory stage. So the drafting of good articles of association, also drafting good and also negotiating the shareholders agreement can take longer time. Let's have a look at the structure of a family holding company. It is similar to all other companies, and as you see, it consists of directors, secretary, shareholders, and auditors. As to directors, a company in Cyprus has to have at least one director, which might be a legal or natural person. You may also decide yourself to be one of the directors or place family members on the board of directors. You have to, however, understand that it can cause shifting the control of the company, which might have tax consequences from Cyprus to another jurisdiction. The work of board of directors can be supported by committees, which may give to the board recommendations and which can advise on certain matters and generally enhance the board productivity. Every company in Cyprus has to also have a secretary, which has more administrative roles, so maybe I will not go here into details. Apart from that, we also have shareholders here. In case the company is supposed to work as an inheritance planning structure, this will be obviously the people who are supposed to inherit. The minimum number of members of shareholders of a company limited by shares, a private one, is 1, and the maximum is 50. So upon reaching this level or exceeding it, the company will effectively become a public company. There are no restrictions as to the nationality, residency of shareholders, and shareholder can be a legal or natural person. Every company, obviously, in Cyprus has to have also auditors and because of that, also accountants. So let's now concentrate for a moment on advantages of a family holding company as an inheritance structure. It's also, I would say, possible to say that it's fast and easy to set up. However, you have to understand that it's still a little bit more effort than the foundation or a trust. The structure is still flexible. Here, let's come back to previous slide. You can participate in the life of the company as one of the directors. Family can be involved also as part of committees. It is also possible to structure the shareholders' rights in many different ways, and also give certain control or involvement into the life of company to the shareholders. For example, by reserving certain matters to the decision of shareholders, meaning that directors, in order to adopt certain decisions, will have to first obtain a consent of shareholders. This is called reserved matters. So, for example, to make bigger investments exceeding certain thresholds, they would have to first have a shareholders meeting to obtain the consent. Shareholders can have also different rights or same, so you can decide to have one class of shareholders having same voting and same dividend rights. So you can also distinguish between the shareholders or give certain shareholders chosen by yourself personal rights. So, for example, a right of a veto. Yes, let's move further. As mentioned, continued commitment of yourself is possible also on the board. However, you have to understand that it can have certain tax consequences. Shareholders have rights as shareholders of every Cyprus companies, which are mainly executed during the annual general meeting of the company. What can also be said about the company, it's a very well established and very recognized structure everywhere in the world, as opposed to, for example, foundation. It is also very difficult to pierce the corporate veil, so the asset protection is pretty strong in case of a company. It is a bit more easy to pierce the veil in case of shareholders being at the same time directors of the company, or in a more unfortunate situation of a company's bankruptcy. Later, let's have a look at enforcement of judgments. Yes, this is something that I have already discussed while discussing trusts. In case of Cyprus, the judgments are easily enforceable within the European Union and also in countries with which Cyprus has respective international treaties. As mentioned before, Cyprus courts can be trusted. We also believe that Cyprus can offer you a very good high quality of work, at the same time keeping the costs at a reasonable level. As to disadvantages, holding company structure do not avoid inheritance rules. This is true to a certain extent. What we have to maybe discuss here briefly, while using a company as an inheritance structure, you may make the shareholders, maybe differently, you can make inheritors shareholders of the company before the death, by either making them shareholders from the scratch or donating the shares, for example. So with respect to those people who became shareholders before the inevitable happens, this can help you to avoid the inheritance rules. However, on a further level, in case any shareholder dies, his shares or her shares belong to his or her estate, and in every time they will be both subject to lengthy probate in case of a death, and also will be divided in accordance with those forced inheritance rules unless a member has also some inheritance planning. Distributions to the members of a company has to be done in accordance with certain strict rules of company's law, meaning that you can only distribute dividends, and dividends can be distributed only from profits which are distributable. If you would like to distribute more, then you have to go through a lengthy and much more complicated procedure of decrease of capital of the company. Because the shares belong to a estate of members, it is possible that this structure will result in alienation of property and also in participation in the whole structure of people that you have not envisaged at the very beginning, such as spouses of members and further people who were not initially planned to inherit. Changes to shareholding. Whereas increasing the share capital of a company is not particularly complicated, however, still much more than adding or, for example, removing beneficiaries in case of a trust. It already have certain procedures from company law that have to be observed. Removing shareholders from the company is something that might be proven much more complicated. Even though you might have a shareholders agreement as recommended at the very beginning, you might not be able to avoid shareholders disputes And in case part of the structure is an operational business, it can simply result in interruption of the business. In case of company, both members and the company itself are subject also to potential claims of creditors. Company also do not give you the same level of confidentiality as is granted by, for example, trust, because shareholders of a company are visible in the register of companies, and everybody can check who is a shareholder. Other disadvantages are potential tax consequences of having excessive rights. And also there is always a risk of misuse or abuse of power by the directors of the company. Last structure I would like to mention a little bit more briefly, because it might not be a structure for everybody. However, I would like you to know that there is something like that on the market as well. It's a fund, which come more from a realm of investments, but more and more often it becomes now used by family offices, also for inheritance planning purposes. A fund is a collective investment undertaking which raises capital from a number of investors with a view to invest it in accordance with a defined policy. If such a fund is used as a closed-end vehicle where the members are only members of the family, and where such fund manages the assets of one family, it can be called a private family fund. As in case of other structures, funds can also be set up in many different jurisdictions. They can also have many different forms. For the purposes of this presentation, we will concentrate on a Cyprus Alternative Investment Fund. In the last years, Cyprus has truly become an European fund hub. According to the data from Cyprus Securities and Exchange Commission, between years 2016 and 2020, the total assets under management of Cyprus Trust has increased by 196%, so which gives maybe a view how much this market is growing. There are three main options as to how the fund can be structured in Cyprus. There is an alternative investment fund with unlimited number of persons. We have also an alternative investment fund with limited number of persons, and also registered alternative investment fund. You cannot choose these types of funds absolutely freely. Which one is the one which might be suitable for yourself? It depends on types of participating investors. If they are, for example, professional investors, well-informed, or retail, it also depends on their number. It also depends on the amount of assets under management and the type of management, whether the fund has to have an external fund manager or it can have an internal one. On top of those three different types of funds, each of them can be organized differently by using a different organizational vehicle, which are variable or fixed capital investment company, a limited liability partnership, or a common fund. The most commonly used in Cyprus for now is an investment company. So later we'll discuss only it. Additional remark from myself, also depending on the type of a fund, some of them require obtaining a license from Cyprus Securities and Exchange Commission. Some of them require only a notification, which is a RIFE, the most, I would say, straightforward one. But each of them requires preparation of certain documents, and definitely creating this structure is much more complicated. Let's have a brief look at the structure of a fund. Every fund has to have an investment manager, which can be either internal or external in case of certain funds. Every fund also has to have an administrator who is providing administrative support with respect to accounting, bookkeeping services, and also calculates the net asset value provides record-keeping services, processes subscription and redemption requests and maintenance, and also is responsible for the maintenance of shareholder register. Funds also have to have a depository or a custodian who is responsible for safekeeping of funds assets in case of financial instruments. If the fund is keeping different types of assets and financial instruments, for example, real estate, what the depository is responsible for is to verify the ownership of such assets, and it has to maintain an up-to-date record of these assets. Also, depending on the fund's scope of activities and type of fund, other key positions might be needed, such as an investment advisor, investment committee, distributor, a legal advisor, compliance officer, and auditor. Let's have a look now at the advantages. One of them being asset pooling. So as a collective investment structure, what funds offers you is a pooling of funds of the family and achieve the economies of scale, and have at the same time the exclusive investment opportunities which might not have been available to yourself if investing alone. Funds also enable family members to provide regular reports on the family wealth and also on individuals' members' net asset value. Funds also allows for structuring inheritance with the use of uniform policies which are governing the participants' ability to redeem out from the structure. Advantage of a fund is also a role and liability of external manager, which in case of negligence regarding the management of fund is liable towards the investors. This role is supported by a whistleblowing role of auditors, who are supposed to bring to the attention of SISEC every event or decision that came to its attention, which relates to the misuse of the assets of the fund. This is also supported by very severe punishments applicable to dishonest service providers. SISEC is allowed even to grant punishments of imprisonment to service providers who are dishonest. Some of the funds, especially those who are fully licensed by SISEC, they also provide regulatory oversight, which might increase also the standards of management by the asset fund managers. Last two advantages I mentioned at the very beginning, Cyprus as a reputable EU fund hub and also very cost-effective jurisdiction. As to these advantages, it's definitely more complex structure, more time-consuming structure. The costs of setting it up and maintenance are higher than in case of different structures because of the licensing process in certain cases and also because of the number of service providers involved into the structure. As mentioned, depository, auditor, and so on and so forth. Changes to shareholding are definitely much more complicated. Also, distributions have to be done in a certain way, as in case of a company. There is also, as in case of company, a risk of potential alienation of property. The structure do not avoid inheritance rules and lengthy probate in case of a death of a member of the structure. The structure, the shareholders and the fund itself, as in case of company, are also open to potential claims by creditors. So now we reach the end of my presentation. Thank you very much. If you have any questions, please feel free to ask them. If no, we strongly encourage you to contact us in person. Let me have a look. How long on average does it take to set up a trust versus a company in Cyprus? Well, as mentioned, a trust can be set up over one meeting, one afternoon. Obviously, there is also a preparatory stage where you have to first meet with the trustees, decide on the particulars of the trust deed, and also if you would like letter of wishes. The company I would say it's around 2 weeks. It also depends if you would like to have a shareholders agreement, how much you would like to change in articles of association, as opposed to a standard articles of association. And I believe that in case of an inheritance planning structure, definitely a bit of changes have to be done. So definitely a trust is a structure which requires less time. What average assets makes establishing trust economically worthy? Well, we believe that it's always worthy to establish a trust if in case you have significant, I would say, assets to be inherited. Also, what we offer to our clients are fees which are adjusted to the amount of assets to be managed by the trust, because they also have to, maybe the fees of trustees have to also take into account the responsibility and liabilities, potential liabilities of a trustee versus the assets he or the trustee is managing. Do we have any other questions? So if not, once again, please feel free to contact us in person. We are very happy to have a call with you to help you, to advise. You can also send us an email. And thank you very much for staying with us, and see you during other sessions.